What's up? What's up? What's up? What's up? All right, let me get my life together. Make that public. I don't know why. Every time I gotta go through this. It seems like I gotta go through this. Welcome to part two. Welcome to part 2 of the disability debacle series. Hang on here. Let me get to the comment section so I can make sure I can see those and make sure I can be seeing on Facebook and on Instagram. All right. What's up, family? How y'all doing? How y'all feeling? Um, I had a tough day today, and I still am here with you all. I'm still here in the pocket, ready to go. All right. I'm hoping to my slides will be better visible, visually today for myself and for you. Okay. I got a little sweatsuit on because I'm in the basement and it's brisk outside. It's cold outside. I got 2 heaters going, but hold on, because one of them is getting on my nerves. Hold on. I think that's that's better. I think you probably could have heard that. All right, so takeaways from disability debacle part 1. I think the greatest takeaway, I tweeted this, was that they accept non-medical evidence. Non-medical evidence, I think a lot of people are overlooking that. All right, but let's get right into it. We're going to start with denials. I'm going to share my, oh God, I got chills. I should have took a shot before I started this because I'm cold. All right, let's get through it. Okay, so the denial rate, first and foremost, the denial rate for disability, the initial application denial rate is 65%. 65%. And it does not get better from there. It doesn't get better from there. Okay. All right. So the first stage in your application, when you submit your application, the first thing you do when you are denied is you ask for reconsideration. This is the first level of your appeal. Okay. First level of your appeal, a different examiner will review your case and any new evidence you submit. And you can make this request online or by mail. All right, here's the kicker. When you get a denial letter, it is going to tell you how many days you have. It usually is 60 days. 60 days. Do not wait. You don't even know how to count 60 days. Is it 60 business days? Do I count the weekends? You might think it's 60 business days, right? So you're only counting Monday through Friday. Well, you're going to be shit out of luck because they counting those weekends. It's 60 days straight, including the weekends. Okay. It's not 60 business days. I know, right? And so you thought 60 business days, you lollygagged and you didn't file your request for reconsideration. So now your whole application is dead, right? You have to start all over again if you want a disability, and it won't be retroactive, right? So when you file this reconsideration, that keeps your application alive, so that if down the road you do get a favorable consideration, then your award would be retroactive to when you applied, right? When you applied and claimed that you were disabled. Okay, so that's why it's important to pursue the appellate process. This is it, the administrative appellate process. Okay, I want to be clear on that because this is not the legal process. This is the administrative process. You don't get to the legal process until you exhaust your administrative remedies, right? So you got to go through this reconsideration first, and the rest of these stages that I'm talking about to exhaust your administrative remedies. And you'll know what I'm talking about when I finish with these slides. All right. So reconsideration is the first step. Now you file for reconsideration. A new examiner looks at that and then goes, no, you're still denied. Okay. So now you need to file for another appeal. Make sure you file your appeal promptly, 60 days from the date of the denial. If you do not file, I'm sorry, I got let me see if I can remove my banner. Can I? Can I? Um, I don't even see it no more. It's been up there so long. Media. Oh, here it is. Let me take that down. Okay. See how much I love y'all? Took my banner down. Bam! 60 days from the date of the denial notice to file your appeal. Missing the deadline can result in dismissal of your appeal and dismissal of your application in its entirety. All right. So again, it's not 60 business days. All right. I should have put that on the slide, but I didn't. I didn't. Take notes. Like I tell my students, take notes. Everything ain't gonna be on the slide. This is a lecture. I'm cold, y'all. Okay, so this is the next stage is when you file for appeal of your reconsideration, you will then be given a hearing. The hearing is before what is called an administrative law judge or an ALJ, administrative law judge. No, I don't know how you become an administrative law judge. I don't know if they're appointed. I don't know if you apply. I don't know. I don't care. If you do, go ahead down that rabbit hole, knock yourself out. Knock yourself out. Come back to the comments and tell us if you find out. Okay, so now you go before the hearing before the administrative law judge. Now, before if you disagree with the reconsideration decision, you can request a hearing. An ALJ who did not take part in the initial decision or reconsideration will review your case. So now you got fresh eyes again on your case. Now, this is a caveat. This is a little carve out. Be careful when considering appealing a partially favorable decision. Sometimes you might get a partially favorable decision, meaning, let's say you've been fighting Social Security for 5 years, and they come back and say, okay, we find that you were disabled for two of those years, and they're willing to pay you for 2 years back pay. But you're like, fuck that. You owe me 5 years back pay, right? If you appeal it, it is possible that you could lose the entirety and get an entirely unfavorable decision, and they could overturn or reverse even the partial favorable decision. So the 2 years that they were going to give you, now you don't get anymore because you appealed and you lost, right? So sometimes a bird in the hand beats two in the bush, right? So these are things that have to be considered. Now, obviously, if you got a full denial, there's nothing for you to consider. You should be appealing. But if you got a partially favorable decision, you might want to consider whether or not appealing is worth losing the partially favorable decision, right? Okay, let's just talk a little bit about the hearing. Let me stop sharing for a second. Let me stop for a second. Let's talk a little bit about the hearing before the administrative law judge. All right. Again, it's not just medical evidence. It is also non-medical evidence. So when you go to the hearing, now this is usually about the time where you might have an attorney. You should, if you're lucky, if you're fortunate enough to find an attorney that will take your case, make sure that you are presenting non-medical evidence at the hearing also, right? Make sure that loved ones testify to what you can and cannot do. Not just the claimant, not just the person who is seeking the disability. They should not be the only ones testifying. I talked about this a little bit before last time because they are not in the best position to assess their own condition, right? They're just not. And relying on them does them a disservice because they're not, they don't fully appreciate the limitations right? Remember, this is new for your claimant, right? This is usually a disability that is now onset. Um, you're young. You're not old enough to retire, right? Or you would be getting retirement benefits, right? So it's sometimes difficult. So make sure that other people testify, not just the claimant. All right. Yeah. Speaking of the claimant, let me let her know I am on YouTube right now. You know what's happening right now. It's dinner time and everybody's texting. What you want? What you want? What you want? What you want? Is that how it is at your house too? What you want? We all in the same house, but don't nobody talk. It's just texting. Everybody's texting from their respective corners. Okay, where was I? Oh, talking about the hearing. All right, so make sure you present not just so when you go to the hearing, you want to take all of the medication that you might be on, right? Make sure you know all of those prescriptions when you take them. If the claimant doesn't know, make sure someone does know. If you don't have them and you can't take them physically, write them all down so you could at least testify about them and get them in the record. All right. Um, yeah, that's the most important thing. Because what happened at the second hearing, um, I did not testify, although I had brought in another attorney for that purpose to make sure that there was non-medical evidence. And the judge basically looked at my mother and was like, "Oh no, this is no need for that, no need for that," and then turned around and tried to deny her. Like, what kind of game y'all playing? All right, so back to the slides. Back to the slides. All right, so you go before the administrative law judge. Now, I want to tell you guys that in between all of these stages, it's we're waiting anywhere between 4 to 6 months, right? Not just for the actual decision or whatever or the hearing, but to be scheduled for it. Like all of this is a really long, protracted, drawn out process. Okay. Um, the administrative law judge, we saw the administrative law judge and we got a decision in June of 2020. I think was it June of 2020? I feel like it was June 2020. No, around it was no, maybe 21. But um I filed the lawsuit in May of 2021 and we did not get that remanded until 22, and then we got another hearing in 23, in May of 23. So this is a long protracted process, guys, what I'm saying. All right, so this is the administrative law journal administrative law judge hears your case, and then once you appear for that, you have to wait for the decision. Again, that's 4 to 6 months, right? All right. So then the law judge, the law judge, the administrative law judge at your hearing denies that. You then can appeal to the appeals council. The appeals council, this is the last step in the administrative review process. Now, if you disagree with the ALJ's decision, you can request a review by the Social Security Appeals Council. The council may deny, dismiss, or grant a review. So in my mom's case, they denied. I will share with you the appeals council denial. All right, let me share that with you. I don't even think I can make this bigger. God damn it. Let me see. Nope. Good one. I'm gonna share it another way. Let me see. Maybe you can see it. All right. So this is the appeals council denial. It's all of 3 pages, And basically, they tell you what we looked at and what rules we applied. Here they say we applied the laws and regulations and rulings in effect at the date we took this action. Under our rules, we review your case for any of the following. The administrative law judge appears to abuse his discretion. There is an error of law. The decision is not supported by such substantial evidence. There is a board policy or procedure issue that may affect public interest. Um, we receive additional evidence, right? And so they say we denied it. They don't say anything more specific than that. It's like this is a pretty much cookie cutter letter. They slap your name at the top and send you the same letter they send everybody else. Now, this is like I said, the last step in your administrative decision. Here, it was June 2020 because then I had to file this. Actually, you're right. I'm right. And you're right. That's the people talking to me in my head. So his decision, the administrative law judge decision, came in June 2020. And then I filed an appeal with the appeals council. And then the appeals council denial. This is dated. Let's see, when was this dated? This is dated. I'll block out the damn date. Yeah, see, it says the decision, the AL administrative law judge's decision dated June 2020. So that's what I appealed to the appeals council. And what the fuck is this thing? March 19, 2021. March 19, 2021. Okay. So that's almost a year for that part of the administrative process, right? So from the administrative law judge, from that hearing to the appeal to the decision, that was almost a year. So I got that March 2021. And so you'll see, you'll see here that it tells you if you disagree with this action, if you disagree with our action, you may ask for court review of the administrative law judge's decision by filing a civil action. That means you must sue the Social Security Administration. That's what that means. You must file a civil action. You versus whoever the administrator of Social Security is at the time. That would be the caption of the lawsuit, right? So mine was my mom, Janet, versus, and it shifted throughout this process. There were the administrator changed, and so we had to change the caption of the case, right? But it's whatever administrator is in position at the time, right? And so the caption of the case could change if the administration changes. In any event, all right, you disagree with the appeals council, then you can file a civil claim. You may file a civil action, ask for court review by filing a complaint in the United States District Court for the judicial district in which you live. That is federal court, people. Federal court. Filing a civil complaint in federal court, right? And for me, it was the Southern District of New York. So I went to file in Central Islip. Okay, that's where I filed. The complaint should name the commissioner of Social Security as the defendant and should include the Social Security number shown at the top of this letter. Now, oh damn, I forgot my thought. What the hell was I about to say? Oh, the cost to file a complaint, a civil complaint in the United States District Court in May of 2021 was $400, right? $400. That was the cost. That was just to file the complaint. That does not include service. You also have to serve the complaint on the Social Security Administrator. And you have to make sure you serve the proper person. And I'm not going to get into that because we'll get further into that process in the next part. All right. You or your representative may deliver copies of the complaint to and the summons issued by the court to the U.S. attorney for the judicial district where you file your complaint as provided by the rule. That so now you have to look up, and I'm going into it a little bit, but just so you know, you have to look up what judicial district covers your area so you can get the proper address to where to send your complaint so you can properly serve Social Security. If you don't send it to the right place, then they won't be properly served and your lawsuit will fail. Okay, so you have to look that up. For us, I believe, I can't remember specifically because I'm supposed to be talking about this part and I didn't refresh my recollection, but I think we had to serve somebody in like Arizona. Yeah, even though there were offices closer, right? Like there's a Manhattan office. I was like, why wouldn't I be serving them right here? Why wouldn't I serve in New York? But it was out of state. So you got to check this little chart that they have at this website. All right. So I'll get into more of this civil action part. But this is more of the administrative appeal part. So I just want to show you, this is the denial from the appeals council. It's all the 3 pages and it's very cookie cutter. Okay. All right. So the appeals council, again, is the last step in the administrative review process. Administrative review process, last step. Okay. Before you can file. Now, once you lose in the appeals council, that's when you can request federal court review. If the appeals council denies your request for review or you disagree with their decision, you can file a lawsuit in the federal district court. That's what I was just explaining. All right. $400 to start that. And so, yeah, lawyers don't want to take these cases unless they're sure they're going to win. They don't want to take them unless they're sure there is going to be some significant back pay for which they can get a percentage of, because that's how lawyers get paid on Social Security cases, right? And so they may not be interested in taking your case if it's only a year old, right? Or 2, because it might not be enough back pay for them to get, all right? And their fee is regulated and monitored by Social Security, right? So they can't bill you without Social Security approving their fee. And so they definitely are not going to take something that they can't make money on. And I know that's shitty, but that's real. They got to eat too. Okay. All right. So here, let's talk a little bit about the denial letter. Damn. Oh, I'm sorry. I'm about to say it's already an hour. Ain't no way. It's almost 30 minutes. So that's cool because we are where we need to be. I'm starving. All right. So the denial letter. When you receive your first denial letter, or in every subsequent denial letter, but when you receive that denial letter, carefully review the denial letter to understand the reasons for the denial and identify areas that need improvement. You have to figure out at what step you were denied. So if you go back to video, don't even have to do that because I brought it. There are 5 steps in the evaluation application process, right? Let's go through those steps really quickly one more time. Step 1 is SGA, right? Substantial gainful activity. I explained what this was in video 1, part 1. Social Security first checks if you're working and earning more than the SGA limit. In 2024, the limit was $1,550. If you are making more than $1,550, you will be denied, no matter what your medical condition is. You're going to be denied. All right. Unless you're blind. If you're blind and you make more than $2,590, you will be denied. All right. So if you are earning above these amounts, you'll typically be denied regardless of your medical condition. So you got to get over that first hurdle. That's the first hurdle. Once you get past that hurdle, and that's usually the easiest of the steps, because most people who are disabled are not working, right? And they're not collecting money or working or income of any substantial, even though that's not fucking substantial. Like, can we talk about that for a second? $1,550 a month. Imagine if that's really all you got. How much do you think your rent would be? Right? Let's say you don't own a home and you rent. let's say your rent is let's pretend that there's some rent out there. Let's say your rent is $1,000 a month. And of course you have to be a single person because you can't afford to feed nobody for a whole month with the $5.50 you got left. Right? Presumably you don't have to take any public transportation or put gas in the car or pay any type of car note or car insurance, or hopefully you don't have a cell phone, or you don't have a light bill, a gas bill. I mean, that's paltry. That's paltry. And for you, for some, I mean, for to be disqualified because you managed to scrape that up a month, that's some old bullshit. Not in one of the richest countries in the world, right? Something's not right with this picture. And what's the discrepancy between blind and non-blind? I don't know. I don't know why why blind individuals are allowed to make $2,590, $1,000 more. If somebody knows that, please tell me. I really want to know. I don't know. Can't post comments to all destiny. You know what, StreamYard? I don't have time for this. It's not letting me see some of the comments. And it's going to be all right too. All right, so that's step 1. Step 2. So this is again, in keep in mind, when you are reviewing your denial letter, you want to see what step you are denied at. All right. Step 2, severity of medical condition. They evaluate whether your medical condition is severe, meaning it significantly limits your ability to perform basic work activities for at least 12 months or is expected to result in death. The condition must interfere with basic work-related activities for your claim to proceed. I think I went over what those are. But these are the things, again, you could have your non-medical people come testify about. What you can and cannot do. You cannot lift. You cannot sit for an extended period of time. You cannot pick up anything over your head. You cannot pick up anything over 5 pounds. You cannot walk on uneven surfaces. You cannot. You have aphasia. My mom had aphasia, meaning that she would speak and she thought she was saying coherent sentences, but she was not. Absolutely was not making any sense whatsoever, right? So those conditions that interfere with your ability to sit, to type, to talk on the phone, right? I'm thinking of, these are the jobs that they're going to say you can do, right? We're going to get to step 5, and that's where the bullshit kicks in. All right, so step 3, severity of your medical condition. Step 3, medical listings. I went over this in part 1. Go back and check it out. Social Security checks if your condition meets or equals one of the conditions in their listing of impairments, all right, often called the Blue Book. These listings describe medical conditions considered severe enough to prevent someone from working. If your condition meets or equals a listing, you're approved for disability, okay? You can be approved at step 3 if your condition meets one of the listings, and I pulled them up before. There are a lot of them, and it would do you justice to review those listings before you even fill out your application, so you can get an idea of the language you should be using when you talk about your conditions and the limitations and your limitations, okay? Because it's smart to mirror their language, okay? All right, step 4, past work. Step 4. So you let's say you have a severity, you have a severe, you pass step 2 and 3, you have something that they acknowledge, but it's not listed. That's what they did for my mom. They said, you have a severe medical condition, but it's not listed, right? So she passed 2, but not 3. So when you don't pass 3, then they go to step 4, right? And step 4 If you pass step 3, there's no step 4, right? So if you pass 2 but fail 3, then they look at step 4. That means they look at your past work. If your condition doesn't meet a listing, right? That's step 3. You fail step 3. They evaluate whether you can perform any of your past work from the last 15 years. Well, remember, they got your work history, right? They consider the physical and mental demands of your past jobs and compare them to your current capabilities. All right. I got a little bit more for that for you coming up to explain what that means. But they're going to look at what you used to do, whether it was skilled work, skilled labor, whether it was unskilled labor. They're going to see whether you can still do that. Okay. And if you cannot, right, you can't do your past work. My mom could not do her past work. All right. So she passed step 4. Then they go to step 5 and they look to see, is there any other work in all of the United goddamn States that you can do, right? So step 5 is they look at other work in the national economy. If you can't do your past work, that means you failed step 4. I know, I told you this shit was layered and complicated, and I told y'all, that's why I'm doing this. If you can't do your past work, Social Security determines if you can adjust to other work. Can you adjust to other work? Based on your age, your education, your past work experience, your transferable skills, your physical and mental limitations. All right. So one of the things I think the judge had said about my mom was she couldn't do her past work, but that she could stand. She could sit for a few minutes, and then she could take 15-minute breaks. I was like, what fucking job is he talking about? And where is this job? I'd like to see it myself, right? But just, y'all just making shit up. It's like, oh God. Anyway, I digress. They also consider if the job exists in significant numbers in the national economy that you could perform despite your limitation. If they determine you can adjust to other work, and they always will determine that you can adjust to other work. Hi, Nandi. If they determine you can adjust to other work, your claim will be denied. All right. If they determine you cannot, you'll be approved. This is where most of the denials happen. The largest percentage of denials happen at step 5, because they always say that there's something you could do. There's some work something you could do. You sitting there, you can sit right there, answer the phone, talk to the people. Yeah. Get up every 15 minutes. And if you have like, they're so unserious. It's like, what? Okay, so there's 5 steps that I just talked to you about. That's a sequential review process, meaning it goes in that order, right? And in the way that I described. And they stop at certain places. And if you pass it, it stops. If you don't, they go to the next one. So this review process is applied in this exact order. And if at any step Social Security can make a determination, they stop there and either approve or deny the claim. Review your denial letter to understand at what step your claim was denied, right? Because when I appealed to the appeals council, my argument was that they fucked up at every step, right? Obviously, if you find that she was legit at step 1, but I think I started with step 3. Right. I think I started with he was wrong at step 3 when he didn't acknowledge that she had a medical listing, right? That she had a vascular insult, a vascular injury, which is listed in the medical listing. So I thought he erred in step 3, right? So I argued step 3. I think I argued step 4. I argued step 5. And I also argued that he failed to I think he failed to complete the record, right? So if there is any medical evidence that is missing, it is the judge's job to get that medical evidence, right? If he knows it's out there, send a subpoena to the doctor. How hard could that be, right? Before he can make that any type of adverse decision, they have to make sure that the record is complete, so that the decision that you're making a decision based on a full record before you, not based on some evidence that might be out here that you did not rightfully consider. All right. So when you review that denial, see where it is, and when you are writing your appeal, make sure you are addressing every step that you did not succeed at. All right, wherever the steps are. All right, so I said this already. Most denials occur at step 5. Step 1, it doesn't happen at step 1 because they have already proven they're not working, right? Above the SGA, that's that 1550, right? So it doesn't happen often at step 1 because that's the easiest to easiest hurdle to jump. 2, have documented a severe medical condition. Step 2 doesn't happen because a lot of people do have severe medical conditions, right? They don't meet or equal listings, but still have significant impairments. That's common. That was also common in my mom's case. Even though when I appealed, I said that that was an error because they did not find that she had a listing. All right, I thought her impairments did meet and equal a listing, more so than any, in any event. Number 4, cannot perform their past work. That was obvious because she worked for Social Security. They knew she couldn't do the work. Right, so that I would have been interesting if he had said, "Yeah, she can do the job." To show up at 26 Federal Plaza. My mother's here to work. Okay, let her in. Yeah, let her in. Let her in. He said she can work. Can you imagine? Can you imagine? Oh God. All right, but at step 5, Social Security often determines they can still perform some type of other work, even if it's unskilled sedentary work, and that's usually what they the decision is, that you could do some work sitting down somewhere, right? And get up every so often, right? Okay. What else I got in here? Let me see. The key factors that frequently lead to step 5 denials include, oh yeah, I forgot I had this. This was good. Being under 50, right? So the first time I think I applied, I was definitely under 50, right? And so, and I think the SJ, I was a little above the SGA because I think I was a little, I don't know, but I was under 50. All right, so it's harder. It's harder to be approved when you are younger. All right, I should have fixed that, but I didn't. All right, having a high school education or above, right? That makes you more marketable. So you are more inclined to be denied if you have a high school education or more. So if you're a dumbass, you in luck. Like, that's not fair. We can't be rewarding the dumb people. Okay, I'm not saying nobody is dumb. Nobody is dumb. That's not what I mean. I just feel like we shouldn't incentivize people, right, to not have an education. I don't know. That just seems so antithetical. Anyway, having transferable skills from past work, obviously that makes sense, because if you can do another job, then they're going to deny you because you can work. Having medical limitations that still allow for sedentary work. That's why when you describe your limitations, you have to make sure you include that you can't sit for extended period of time if that's part of your condition. Of course, I'm not suggesting that you throw that in there if that's not a legitimate concern of yours. But keep in mind, sometimes people forget to mention things like that, right? You can't stand for extended periods of time. If you walk with an aid, a cane or walker, right? It might be difficult for you to sit as well. So you have to put that. You have to make sure you are clear on what your limitations are. All right, I got a couple more factors. Other common reasons for denial. Second most common point for denial, step 2, where Social Security determines the condition isn't severe enough or won't last 12 months. All right. However, step 5 remains the biggest hurdle in the disability determination process. All right. So step 2, again, they determine whether or not you have a severe limitation. And if you have not demonstrated that either via medical evidence or non-medical evidence, then you'll lose at step 2, right? You'll lose at step 2, and then they'll stop there. All right. Step 5, other work. I think I already showed you that. Oh, yeah. No, I didn't. When they are considering other work, they have a grid. This is some weird calculation that they use. All right. When considering other work, Social Security uses a complex framework called the Medical Vocational Guidelines. At the hearing that we talked about with the administrative law judge, they often have a vocational expert, right? So these vocational guidelines, also known as the grid rules, they accompany testimony from the vocational expert. The vocational expert looks at what you have claimed are your limitations, and they determine whether or not there's any work that you can do with those limitations, right? And so this is some of the what they are determining. They first determine whether or not you have residual functional capacity. This is called RFC. This is what you can still do despite your limitations. This is what the vocational expert is going to say. This is happening in step 5, all right? If you have residual functional capacity, that means you have physical abilities. You can sit, you can stand, you can lift, you can carry, right? Mental abilities, that means you follow instructions well, you can deal with stress, you can interact with others. You have environmental limitations, exposure to heights and temperatures, things like that are going to affect whether or not you can, the vocational expert is going to say that there is other work that you can do. All right. So if they determine that you don't have these limitations and you have residual functional capacity, they are going to find, I'm sorry, I didn't lean out of the frame. I'm tired, y'all. They're going to find that you can do other work. Okay. That's what they're going to find. All right. RFC continue. After they do that, after they determine whether or not, let me see, after they determine your residual functional capacity, right? Whether you have these physical, mental, and environmental limitations. After they determine that you do not, usually they don't, then they classify your level, your RFC level, right? Whether you can do sedentary work, which means lifting up to 10 pounds, whether you can do light work, which means lifting up to 20 pounds, medium work, which means lifting up to 50 pounds, and heavy work, which means lifting up to 100 pounds. All right. They then look at your age category, right? Because that significantly impacts their decision. If you are 18 to 49, you will likely be denied, especially if they can find that you can do light, medium, or heavy work with your limitations, right? So the younger you are, the more likely you are expected to adjust to other work, right? So if you're 18 to 49, that increases your likelihood for denial because they expect that you will adjust to other work, okay? Ages 50 to 54, hey, yeah, closely approaching advanced age, fuck you, Ronnie. Like, that's not fair. I need to sit with that for a minute. Oh, that hurts. Wait, I'm closely approaching advanced age, y'all. So I may have difficulty adjusting to other work. All right. So based on your age, this is what they mean by where your RFC level is. They factor in to what type of work you are and your age level, right? So I am closely approaching advanced age. I may have some difficulty adjusting. That would increase my odds for being approved, right? That's what we're talking about relative to your denial and approval odds, your RFC, right? So then age 55 is advanced age. I am not far from that, goddamn. I'm not far from that. I'm not far from that. Significantly limited in ability to adjust. Like, what does that say about us? I know I'm in my bag for a second. Y'all just give me a minute. Significantly limited in ability to adjust. I know a few men like that. Leave me alone. This is my YouTube channel. I can do what I want to do. And right now I'm having a good time talking to myself. All right, age 60, closely approaching retirement age, very limited in ability to adjust. That greatly increases your odds to be approved for disability. Also, because you closely are approaching retirement age and you cannot receive both disability and retirement benefits, right? So once you reach retirement age, your disability benefits will convert to retirement benefits. All right. That's a trip. Closely approaching advanced age. Mm-mm. I need a t-shirt with that. RFC continue. Education level also is considered in your RFC. Education level is categorized as illiterate or unable to communicate in English. Obviously, if you are illiterate and unable to communicate in English, if you are an older person and you are unskilled, that will increase the likelihood that there is no other work for you. Y'all see how this is going? Excuse me. How you can put these factors together in the residual functional capacity and how they make a determination. All right, I got some examples for you. But all right, so then the next level is categorized as limited education. That's 7th through 11th grade, high school graduate or equivalent, recent education that provides for direct entry into skill work. That would probably be like a certificate or trade work, things like that, or college education. All right, so obviously, if we grade this, it the higher you are on the education level, the less likely you are to be approved for disability. You see a pattern here? All right. Previous work experience is also classified as unskilled, semi-unskilled, with or without transferable skills, or skilled. Well, get off my thing. How dare you? I can't see it now. Oh, wait. Okay, sorry. Semi-skilled with or without transferable skills, or skilled with or without transferable skills. All right, so they're going to classify that as well. So now let's say if you are let's go back. If you are closely approaching advanced age, right, and you can only do sedentary work, right, and you have limited education, and you are unskilled, right? So those are the factors, right? That's going to determine whether or not you are approved. In that scenario, that person likely would be approved, right? Because they likely cannot get other work, right? Other work. All right, I got a couple of examples. All right, Social Security uses these factors along with the grid rules to determine if you can adjust to other work. I said that. Now, here's a couple of examples. For example, a 45-year-old high school graduate limited to sedentary work would likely be denied because he can find other work, right? Remember that age group. We go back, 18 to 49. This person in that hypothetical was 45. That's a younger person, all right? A younger person is expected to adjust to other work. Okay, so in that hypothetical, that younger person who is a high school graduate, right, even though they're limited to sedentary work, they likely can find other work. Contrast that with a 55-year-old with limited education. And if we go back to our limited education is less than high school, that's 7th through 11th grade, right? 7th through 11th grade. So we've got a 55-year-old with a 7th through 11th grade education, and they are relegated to sedentary work. Remember what sedentary work was. We go back, sedentary work is lifting up only 10 pounds. They can only lift 10 pounds, right? So that's our 55-year-old person with 7th through 11th grade education can only lift 10 pounds. They would likely be approved because it's going to be difficult for them to find other work in the national economy. Okay. I'm hoping, I hope this is making sense. I hope it's making sense. Okay. Because that is the end of my slide presentation. Yes, I watch too much Doug and Carrie. I know. I like the Kings, Queens. Leave me alone. Okay. I can't see the comments for some reason. I'm sorry. I don't know why. But put them in the respective comment section from whence you are watching. I'm gonna go find me some food, and I will do my best to come and back at some point and answer those questions for you guys. All right. I hope this was helpful. I hope you were able to see the slides better this time. I think you were. I think this was good. I think this was very good. Y'all tell me what the takeaways are. Y'all tell me what was the most helpful parts. I think this was probably clearer than part one. See, I'm getting better. I'm getting better. Now I'm getting better. Yup. Okay. All right, family. Look at that. Almost on time. Almost 1 hour. I said I didn't want to go over an hour. All right. So I'm going to end it here. And put your comments in the comment section, like I said, and I'll do my best to answer those questions. All right. Part three next week, Thursday. We're going to get into the federal lawsuit part, filing a federal lawsuit, how to find out who you are suing, who is the head of Social Security, how to find that out, how to find out who you're supposed to serve. What do you mean judicial districts? What the hell? Let's get into that next Thursday at 7:30, if you'd be so kind to join me. All right. So join me here. If you are up Thursday morning, turn on Urban View and catch the segment Talk to Your Lawyer, where I will be talking. I'm on there usually every Thursday at 8 a.m. It's Urban View channel 126. I'm on with Lamar King and Dr. Greg Carr. So tune in. They're on from 7 to 10. I jump on at 8. It's always a good time. You know, it's always a good time when Ike's in the house. All right. Thank you, Lisa. I appreciate you. I'm so glad that you said that. Thank you, sis. I appreciate that. And she said it was very helpful, all of it. Excellent. We got to navigate the labyrinth that is the Social Security Administration, and we can do it. We can do it together. All right. We can do it together. All right. I appreciate y'all. It's your girl Ike here. You know I love you. I really do. All right. Y'all be good. Have a great week. I'll see y'all around. Peace. Yes, in my